Hello everyone. I'm Greg Chambers, an Associate Director in Osborne Clarke's International Employment Law team. Welcome to today's webinar, where I'm going to spend a little under half an hour talking about the changing world of work, focusing on some key employment law considerations for what is being described as the Fourth Industrial Revolution. To begin, I'll quickly run through our agenda. After making some initial remarks about the Fourth Industrial Revolution, I'll identify a constellation of emerging employment law and HR issues. I'll then highlight some recruitment issues in the age of robotics and artificial intelligence before I offer my conclusions. So, you'll have heard economists and futurologists talking in terms of a Fourth Industrial Revolution. The first was powered by water and steam. The second was the age of electricity and mass production. The third harnessed electronics and information technology to automate production. And today the global economy stands on the brink of a fourth industrial revolution driven by breakthroughs in fields like artificial intelligence, robotics, the Internet of Things, autonomous vehicles, 3D printing, quantum computing, and nanotechnology. Some commentators are describing the age we're living through as an even more dramatic shift. The world had an agricultural revolution, it had an industrial revolution, and much more recently a digital revolution. And now we're on the cusp of another tech revolution that will have as profound an impact on the world of work as any of those earlier revolutions. In this webinar, I'll be raising several questions which we should start to think through now. Some of you will have been already. I'll be identifying a range of employment law implications which I've seen in my practice already, and some which I predict. And I'll be drawing out three key themes which will, I believe, help guide us through many of the employment law and HR considerations of the future. If handled carefully, there are great opportunities to harness these technologies to, of course, grow businesses, and speaking as an employment lawyer, to improve working lives. Of course, when it comes to the workplace, businesses will be implementing these technologies against a backdrop of employment law, which, as you'll know, derives from contracts, court decisions, and legislation. Now, tech innovation always outpaces legislation. This means we'll see plenty of test cases hitting the headlines, where courts will be getting their heads around applying existing laws to disruptive technologies and new ways of working. You've seen this recently in the gig or task-based economy, with some Uber drivers and various other workers who deliver their services via apps, using the courts to challenge their employment status. In the UK, they've argued, so far successfully, that they aren't really independent contractors and are workers, which is a legal category that gives them more rights and Uber more costs. And we'll see governments responding by considering legislative reforms. An early example of this is that in October last year, Theresa May commissioned Tony Blair's former policy supremo, Matthew Taylor, to carry out an independent review into employment practices in the modern economy, with a remit which included looking at gig working. His report was published in July this year, and we await the government's response. So, over the next few years, we're going to see some new employment laws and some old employment laws applied in new contexts. What I've identified on this slide is a whole constellation of areas which will have an employment law or HR dimension. Sadly, I can't cover all 9 today, so I'll quickly list them for you before I focus on the last 3, which are especially relevant for today's session. First up, employment status issues in the gig economy. I've just mentioned the Uber employment status litigation, and correctly classifying workers who are delivering their services via digital platforms isn't just relevant to the employment rights that they might enjoy, it's also very important to the Treasury, because if these platform workers are self-employed, then the Treasury misses out on payroll taxes and national insurance that it would have received in respect of traditionally engaged employees. Second, We'll see more trade union recognition issues in the gig economy. The Independent Workers' Union of Great Britain are currently litigating to try to force Deliveroo to recognise them for collective bargaining purposes. Third, we should take a fresh look at how to protect businesses from inappropriate employee competition in a digital world where business is increasingly transacted online and more connections are made via LinkedIn and other platforms. We'll, for instance, need modern restricted covenants and social or professional networking policies. Fourth, health and safety issues, both in workplaces that incorporate robotic labour, what if the robot malfunctions, and in home or remote working. How does health and safety law operate when the employer has much less control over the environment in which someone is working? Fifth, employment laws around job displacement, job losses, and perhaps new obligations on employers who replace humans with robots. On this, some people are, of course, predicting significant job losses. Others are a lot more optimistic, though, and point out that in the last 60 years, at any rate, automation has only eliminated one occupation, that's elevator operators. Sixth, we'll see more employment law issues which have an international dimension. For instance, issues around which country's laws apply in a borderless workplace where you might have workers in one country using telemanipulation to operate robots in another country, or where you crowdsource tasks and the crowd workers are located in several countries. 7, legal issues around introducing or scaling up these new technologies, particularly training, employee consultation, and contractual issues. 8, equal opportunities in the future workplace and job market. And 9, the rise of big data in the workplace and the data protection issues around that. I'll now look at 7, 8, and 9 in a little more detail. Introducing new technology, training, consulting, and contractual issues. It's clear that technology can amplify human capabilities. This will drive efficiency and productivity and will be a win-win for the business and the worker if the technology can liberate the worker to focus on higher value functions, free us from the drudgery. I'm sure we can all think of some aspects of our working lives which we'd happily delegate to a robot if that meant we spent more of our time on the creative aspects of our jobs which led us to choose our careers in the first place. Technology is, of course, also enabling more agile working, giving more flexibility over where and when people do their work, whether that's working from home, working in spaces shared with clients or cross-disciplinary teams of professionals working on the same project, or whether that's working on a beach. We'll also see a greater demand for work that's flexible enough to allow people to pursue their passions outside of work, whether that's hobbies, community work, charity work, you name it. When it comes to portfolio careers, doing more than one job concurrently, it struck me that when I graduated, people were saying that the job for life was a thing of the past and that people would now have several different jobs over their career arcs. The change is that people graduating now are increasingly expecting to diversify their careers so that they're doing several different jobs at the same time. I foresee that successfully adopting these new technologies and new ways of working will require businesses to, first, train the managers, for instance, on how they can manage teams of remote workers so that the business retains its culture. Allied to this focus on culture, I'll be advising clients to train managers on how to make sure that geographically dispersed teams of people retain their team spirit, and on how to ensure that the business and employees maintain the mutual trust and confidence which is at the heart of employment relationships and which will only get more important with agile working. Team leaders will also need to be trained on how to deal with performance issues involving employees who don't work in the office and on complying with the employer's duty of care. including avoiding situations where some remote workers could suffer from loneliness and isolation. Having the chance to work remotely clearly gives some people fantastic freedom and flexibility, makes them happier. But for others, it could do the opposite, and we'll need to be alive to that. Second, train employees. It's always been the case that to maximise productivity, you need the right workers with the right training using the right kit. This will be even more profoundly the case when the kit in question includes highly advanced technologies which change rapidly. And managers will need to prepare workers for unavoidable changes to their current jobs, enabling them to upskill and specialise where necessary. This will in turn entail consulting with employees or their representatives about new technology and how it will affect them. This is essential in maintaining trust. You'll hear the word trust from me several times today because I forecast it will be a key theme in years ahead, both in the sense of making sure that in changing times we don't breach the term trust and confidence, which courts imply into all employment contracts, and also in the sense of building the trust and buy-in from colleagues which is needed to make a success of introducing change. Another contractual issue will be the need to ask for some employees express consent to altering their roles or changing their terms and conditions. And occasionally, employers will need to consider how to respond to refuseniks or dissenters in ways which are sensitive and legally compliant. The second topic I'd like to focus on is equal opportunities in the future workplace and the discrimination law which goes with that. On the slide, I've identified two types of discrimination to avoid and one opportunity to explore. First, employers will need to avoid discriminating on grounds of age. Unless handled carefully, the use of advanced robotics and AI in the workplace could lead to accusations of age discrimination based on older workers' comparative lack of familiarity with new technologies. If, say, employees over a particular age are less familiar with working with a particular technology than younger employees are, then recruitment or promotion decisions based on this familiarity would affect the older age group disproportionately. The business would then need to look at objective justification arguments. Second, it will be necessary to avoid discriminating on grounds of nationality. I flag this because technology operated by voice command could potentially disadvantage individuals whose first language isn't English. Now for an opportunity to explore. When it comes to disability discrimination, there will be new frontiers of the duty to make reasonable adjustments in respect of disabled workers. For instance, technology will enable people to do roles previously closed to them. Think about the robotic exoskeletons, which are already being used in South Korea to give dockers genuinely superhuman strength, or self-driving cars, which could open up jobs previously denied to blind applicants. The last of my three highlighted topics is the use of big data in the workplace and the privacy issues that will result. Now, big data will have major applications in the workplace. For instance, using artificial intelligence to analyse large data sets to determine exactly which employees in large organisations will form the best teams for particular projects. The technology already exists, which in theory enables employers to monitor almost everything their workers do. Wearable technology like smartwatches and fitness bands has already been rolled out in support of some workforce wellness programs. I'm thinking here of apps like MyFitnessPal, coupled with the use of GPS tracking. And what about using wearable tech to monitor the productivity of remote or agile workers? Or as a more general management tool? Could we be entering a brave new world of managers equipped with a dashboard of employee performance data, as well as their fatigue and sleep levels gathered from wearables? Or would that be an undesirable world of Big Brother is watching you? In which case the relevant novel would of course be 1984, not Brave New World. What is clear is that there will be vital privacy and data protection issues to consider. For instance, before contemplating using advances in big data to gather and analyse employees' personal data, you should give careful consideration to the following: carrying out an impact assessment of how you can comply with the General Data Protection Regulation, or GDPR, which will have full legal effect from May 2018. Considering developing codes of conduct and updating employee monitoring policies and involving employees or their unions in this. Looking at the GDPR to decide whether you can rely on explicit informed consent of the worker to gather their personal data, and further consent to correlate it with other data such as performance metrics. It's important to note that consent to processing personal data must be freely given, which can raise issues in the employment context. Now, processing data can also potentially be lawful if you have legitimate interests for doing so, but my main tip here is to take specialist advice from one of my Osborne Clarke data protection colleagues who are on the cutting edge of advising in this area. Finally, be open and transparent with employees so that you don't breach the employment-implied duty of trust and confidence. Okay, I'll now wrap up this first section of the webinar. I'm going to do that by drawing out 3 themes. The first is trust. Maintaining it is a key employment law principle and will be fundamental to successfully introducing sometimes pretty radical new technologies and working practices. Second, culture. In the face of such profound change, I strongly believe it's critical to ask ourselves, what is it that makes our particular organisations distinctive? What is it about them that we'd like to bottle? Let's make sure we use technology to protect and enhance that. Let's make sure we don't introduce changes in a way that endangers it. Third, diversity. Let's of course ensure we don't roll technology out in ways that unintentionally discriminate against particular groups. And let's explore how to use technology and innovative working practices to boost diversity and equal opportunities. In this second section, I'm going to reflect briefly on some employment law implications around recruitment in the age of robotics and artificial intelligence. We've already read that advanced robotics and AI poses a risk to human jobs. We'll have seen that in the news frequently over recent months. How big a risk is a hotly contested topic, but I'm going to focus on the positives, which are that employers will still seek human workers for knowledge-based roles, particularly where there's an emphasis on creativity and complex problem solving, even if artificial intelligence may already be catching up in these areas. And relationship-based roles, basically things machines can't do well, like empathizing. And as it has done in the past, technology will help create new roles, some of which we haven't even dreamed of yet. Another positive development in recruitment is that I think there's a real equality opportunity, which is this. AI and big data has the potential to crack open the labour market to wider groups of people so that we recruit the most talented people from more diverse backgrounds. Algorithms will increasingly be used to try to eliminate the all too human elements of bias and unconscious prejudice from recruitment processes. But a word of warning. Algorithms and automation are double-edged swords. Back in 1986, St George's Hospital in London implemented a recruitment process that was racially and sexually discriminatory when it automated its admissions process based on data collected in the 1970s. The computer program looked at the sort of candidates who had been successful in the past and gave similar people interviews. Unsurprisingly, the people the computer considered suitable were male and had names that looked Anglo-Saxon. St George's had to scrap this process in a hurry. Now, the lessons here are to train staff involved with recruitment and carefully set parameters with your external recruiters. If moving to algorithmic systems, seek ones out that enable you and your recruiters to identify new talent pools and which are consciously designed to improve diversity and reduce bias. Consider reviewing your existing recruitment processes and, self-interest disclaimer here, certainly take legal advice on any innovative ones you may think about introducing. That's so that you and your applicants can trust that there won't be inadvertent discrimination coded into the system, and also so that you don't fall foul of some strict data protection requirements in the GDPR when it comes to making significant decisions about individuals without there having been much, if any, human intervention. For my penultimate slide, I'm going to look at some ways we might rethink employment contracts to recruit and retain the workers of the future. It may be that we're moving beyond the binary work-life balance, or a work-life divide, with work being work on one side and life being totally separate on the other side, to something more like an integration of four things: work, home, community, and personal time, or me time. These four domains, of course, can't always work in perfect harmony. That would be a utopia, but we can certainly think innovatively about how we can attract and retain workers by helping them achieve as many four-way wins as possible. And we can be mindful of this when drafting forward-thinking offer letters and employment contracts. For instance, will you want to make home or agile working easy and ensure that it won't be a barrier to progression? And when it comes to agile workers' contracts, which expenses will you cover? For instance, communications expenses, travel to and from the office. The European social partners issued a voluntary framework agreement on telework in 2002, which suggests that if homework is performed on a regular basis, the employer should cover all direct costs. This agreement is non-binding in the UK, but in France, for instance, home working costs do have to be reimbursed, and the business must indemnify or compensate the employee for home working if that home working is at the business's request. Another point is, how will you define the boundaries of working time? When should agile workers be available? How to address the risk that some people may work in excess of legal limits without you knowing about it? And if you monitor these hours, will all the monitoring meet data protection requirements? The contract will need to strike the right balance between an employee's private and family life and reserving a right to enter their premises, for instance, to install or collect equipment or carry out health and safety risk assessments. Training. What training opportunities will you offer? What training will you require? Will you do this training in-house or partner with external providers? Outside interest clauses. Now, traditionally, employment contracts have focused on what outside interests or outside activities to prohibit. That will remain important when it comes to restricting inappropriate employee competition. But what outside activities will you permit or actively encourage if they will help attract talent and spark creativity? Will you trust employees to determine their own working hours and let them decide when to work for you and when to pursue their outside interests or do the other jobs in their portfolios? If so, how will you sanction them if they abuse that trust? Of course, the reason for applying fresh thinking to these questions is so you have employment contracts which will continue to reflect your culture in a changing world of work, and which will help build the trust necessary to underpin increasingly autonomous ways of working, and which will help you attract the best candidates from diverse backgrounds. So, to conclude, this has brought me back to the three themes I've been returning to: trust, culture, diversity. These are three things or ideas which I believe businesses must keep firmly in mind if they are to successfully negotiate the key employment law, HR, and recruitment decisions of the rest of the 21st century. When it comes to trust, it's long been the basic building block of all employment relationships. Today I've explained why, in my view, it will become even more important in future. Culture. Think about what is distinctive about your organisation and protected at all costs. Diversity. Ensure that you're not unintentionally discriminating against particular groups of people, whether that's during recruitment or employment, and seize the opportunities which new technologies and ways of working will give to boost diversity. This brings me to a close. I hope this has been a helpful survey of what I predict will be key issues for employers as the global economy adapts to a period of profound technological change. Thank you.